the Women in Business podcast. Insights from top financial professionals. Strategies to grow your practice. The future is female. It all begins here.
Welcome back to another episode of Gradient Women in Business, where we share stories, strategies, and inspiration from some of the most remarkable women shaping the future of financial advising. I'm your host, Jaclyn, and today we're diving into a topic that's easy to overlook, but absolutely vital: beneficiary designations. Our co-host is the wonderful Karen Dowling, and an experienced financial advisor who is passionate about helping clients protect their legacy. Karen, it's such a pleasure to have you here. Welcome.
Thank you so much. I'm so thrilled to be here. And although we're talking about a topic that's not real flashy, it still is an essential topic and the most impactful. If done wrong, can completely derail someone's estate plan.
Yeah, no kidding. And so let's start at the beginning, Karen. I mean, what exactly is a beneficiary designation and why does it carry so much weight?
Well, your beneficiary designation is simply the form that you fill out when you are opening an account, whether it's the bank, a savings account, an investment, an annuity, life insurance. It is what you are assigning as your beneficiary, who is going to be the person that is going to receive the funds upon your passing.
Yeah.
And so, for this reason, it's powerful, and it will override your will.
Oh, well, that's great to know too. So if someone updates their will but forgets to update their 401k beneficiary, I mean, the old form still controls, right?
Exactly. The old form decides who inherits. And, no matter what your will or trust say, and we're going to come up with some examples here, but I've seen this in heartbreaking ways in the past that, you what trumps a trust and a will is that beneficiary designation
Wow.
form.
That's pretty
And
important.
yeah, I have, worked with families and there was a husband who remarried and wanted his new wife to receive the funds for his 401k.
Hmm.
However, he did not change that beneficiary, and when he passed, unfortunately, it was still with his ex-wife, and there
Oof.
was nothing that she could do about it. So, it was legally airtight. The plan administrator has to go with that, designation form.
Wow. That sounds like it can be a nightmare.
It is, and we see this play out in, even the case of Kennedy versus DuPont. I think,
Tell me more about that.
so this one went all the way to the Supreme Court, and
Okay.
this one was William Kennedy, who worked for DuPont,
Hmm.
and he had designated, at the time he was married to Liv, and he had designated his wife as the beneficiary of his
Estate.
well, he actually had it for that DuPont savings and investment plan.
Okay.
For his, at the time, like years later, they end up divorcing. They ended up, she signed in the divorce decree, she relinquished her rights to his retirement plan, which is unusual. We don't know what the details of that,
Hmm.
but maybe there was a great settlement for her and therefore she relinquished that. However, he did establish a will, and a trust, excuse
Yeah.
me. And in that trust, he was giving all of his assets and having his daughter as the beneficiary of his trust. So his assumption at that time, I presume, was that when he passed, everything would go to his daughter. However, he never went back to that DuPont savings and investment plan and changed the designation of the beneficiary. And so when he passed, everything went to Liv and not to the daughter. And the
Oh,
daughter ended up having, went back to the mom. Mom did not turn over the funds. The daughter actually had to sue DuPont, and it went all the way up to the Supreme Court, in which they firmly stood behind the document because
yes.
the documentation of the plan administrator had, which was the beneficiary designation, was her as the beneficiary over the trust.
Wow. So what you're saying is the ex-wife or mother in this situation, signed paperwork saying that she wouldn't claim the money?
In the divorce decree, and they did not, you would think that there would have been a quadro or qualified domestic release, order, but there wasn't.
Okay.
She just had it in their divorce decree that she was relinquishing, but that is not what stood in court. It
Eh,
was the plan administrator's document that he had her as the beneficiary of that DuPont savings and investment plan.
Yeah. So what you're saying, so the Supreme Court couldn't undo this?
No. No, absolutely not. They
That
firmly stood by that, and, um, unfortunately, if you don't update your forms,
yeah.
you could be disinheriting your, your kids or whomever that you want, your wishes to go to,
Yeah.
your wealth to go to.
Yeah, absolutely. And this is a great I mean, not a terrible situation,
Yes.
but it's something to reference and to use, and so you kind of talked about signing these forms, making sure, but can you explain what is the best practice and how often should people be reviewing their beneficiaries?
Absolutely, every year you should be doing your review. I mean,
Okay.
most of us do an annual review with our clients, and so why not incorporate that into there? Gradient is great about having a beneficiary report that they're actually improving that as we speak. And so, unless there's a major life event like a marriage or a divorce or a death or a new baby coming into the
Yes.
family where there warrants a change in that beneficiary.
Mhm.
However, for the most part, it's a great time to bring that client in and have that added value service and say, let's go through that beneficiary report and see whether it's an internal account or an external account. We want to look comprehensively because you may have the opportunity then to see what other outside financial advisors they may have that aren't providing this service
Mhm.
and could be really having some detrimental effect on their overall estate plan.
Yeah, no kidding. And Karen, you've seen this play out firsthand. So tell us about this Florida couple example that you have.
So, not that long ago over the summer, we had a married couple who, in our reviews, we asked them to name each other as primary
Mhm.
beneficiaries.
First
That's
step.
standard. Right. However, we emphasized that they needed to set up a contingent beneficiary. It was essential. Oftentimes, this is one step that is forgotten. Um, and I think even, additionally, people forget to put beneficiaries on their bank accounts, savings and
Mm.
checking, and that's essential. And I'll tell you a story about that in just a second. But in this particular case of the Florida couple, she passed away, and 2 days later, he passed away.
2
And
days.
yes, and that didn't satisfy the 30-day rule that is required for the beneficiaries, and therefore, it ended up having to go to probate. So, there was no contingent beneficiary on their accounts, And so they did have each other,
Mhm.
which was great, but neither one of them passed the 30-day
That's just
ruling on it.
tragic.
It really was sad because it's costly to end up
Mhm.
having to get letters of office and go through probate, not to mention that someone else, a court, is deciding how your estate should be settled
Yeah.
instead of you. And
Yeah.
so that's one area that we would encourage people get that contingent beneficiary on there.
Yeah. And so you briefly mentioned it before, and we were chatting before we are doing this podcast
Mhm.
about this couple with their bank accounts. And so you have a great example of that and something that's definitely preventable. So can you share about that?
So I had a client call me up, and her husband was basically on his deathbed, and he had over 100,000 in the bank, and she was not the beneficiary at all on this bank account. He was
Mhm.
the sole person on this bank account. And normally, you would have the power of attorney for financial matters be able to manage that. However, in this case, she had an old version of it where she had to get two doctors to go and basically acknowledge that he was incapacitated and could not um, handle his financial
Mhm.
affairs. This took the course of almost a week. Started on a Tuesday. By Friday, she finally was able to get two doctors in the hospital to sign off on these the required bank
Mhm.
documents, acknowledging that he was incapacitated. She was able to pull the money out of the bank, and he passed away that evening. Otherwise,
Wow.
she would have been going to probate herself. And so that was another exercise that um, is something that we encourage people. Go look at your bank accounts. Is there a transfer on death in
Mhm.
there? Oftentimes, with custodial accounts or your your Schwab or your Pershings and other accounts that
Fidelity.
Fidelities
Yep.
and so forth, you might have a individual account or a joint account, and on their application, they don't necessarily ask for the
Beneficiary.
beneficiary.
Wow.
Now they will on a qualified account, and they definitely will on, the trust account. The trust account's going to be the trust as the beneficiary, and they will ask that on a qualified account. On a non-qualified account, like your individual or joint,
Mhm.
you have to present the transfer on death paperwork. So, just another example of why you need to be doing these
Yes.
reviews with clients.
Yes. Well, it almost seems to me like it's a trick. Like
Right.
why is it so hidden in there to do this? Why isn't it just automatic, right?
It just seems odd that it wouldn't be part of the application,
Absolutely.
and I
Absolutely.
agree.
And what you're telling me too is so the set it and forget it mentality just does not work here and especially with beneficiaries.
Correct, correct.
So, what are the most common mistakes that you see with beneficiary forms?
I would say not putting that contingent beneficiary on there. If that primary beneficiary dies first, the account would be going to probate. Um, I find secondary that they're putting minors on there as the beneficiaries, as the primary, maybe
Mhm.
even as the contingent. That, as well. You might have the spouse, and then you might have the, children,
Mhm.
where the children are minors. In that case, you would be better off having the trust be the contingent beneficiaries, because without a trust, that, the court is going to, be deciding, um, well, first they're gonna appoint a guardian, and, the guardian is going to be the one that's going to manage the funds for
Mhm.
anybody under 18. Well, do you really want a guardian ad litem or someone outside of the family
Mhm.
managing those funds? Probably
No.
not. So, um The other, I would say, thirdly, forgetting to update, after life changes, to, um, for example, ex-spouses, removing ex-spouses. We saw
Yes.
how detrimental that was in, DuPont
More
and
than one cases.
yes,
Yeah.
yes, dangerous. And then assuming that your trust or your will is gonna cover everything
Mhm.
and, not realizing that your designation, on your beneficiary forms trumps everything. And it
Yes.
seems counterintuitive, but it's not.
Yeah, it's not.
Yeah.
It's
Eh,
yeah. So can you share an example of maybe one of these?
well, we had a situation where, a client named their 3 children as beneficiaries on their life insurance, and years later, they, passed, and this was an interesting one because one word made a huge difference. They did not put on there that how it was going to pass, to those 3 children, whether or not you have the option per capita or
Mhm.
meaning if living or per
Okay.
stirpes, meaning in the bloodline. So if any of the children had children, then it could go and one of those children pass before, the parent passes, it would go to their children, meaning the grandchildren. In this case, the child died, had 2 children, and then the parent died because the parent never updated their beneficiary form,
Mhm.
and it went 50-50 to the other 2 siblings. So, without realizing it, that parent disinherited their grandchildren.
Mhm.
And that is unfortunate. They
Mhm.
obviously did not have that intention. And so by not putting per stirpes on there, and then it would have been that third of the inheritance would have been shared by the 2 grandchildren, and the other 2/3 would go to the other
Mhm.
the aunt and or uncle,
Yeah.
the other children. Um, she, essentially ended up disinheriting her grandchildren.
Wow. Okay.
Yeah,
I mean,
so
so a few words on a form can change the entire outcome is what you're saying.
absolutely.
Eh,
Shocking, yeah.
yeah, and it's so sad to hear. But Karen, here's something I hear all the time. Should someone name their trust as a beneficiary of an account or should they name individuals directly?
Well, that's a trick question. I have to say it depends.
Okay.
You know, where you can name an individual, I would say, you know, that would be the ideal situation.
Mhm.
But when you have minor children, you're not going to name those, as I had mentioned before, because it ends up going to a guardian
Mhm.
and goes to court. And so in those cases, having it go to the trust, then the trustee would put it into a special needs trust for the health, welfare, and education
Yeah.
benefit of those minors until they reach the age of maturity, 18, and
Okay.
then it could pass on. Or maybe in the trust, the parent may have stated that they don't want the funds to go there until age 25, or what we recommend, age 30 or 35, because
Really?
that's when they have a more mature understanding of handling finances.
Absolutely. You're
And so
independent on your own at that point, so you're just
correct,
growing and it's a plus rather than a dependent.
correct.
Yeah.
And then you'll have situations where someone might be, autistic, someone might have a disability,
Mhm.
and you could actually knock them off of their funding that they received
Mhm.
from the government if they outright receive funds. So that would not be a prudent thing to for them to outright receive those inheritance, it's best for them to keep it within the trust and the trustee whenever they need, any funds to distribute it at that time.
Yes.
They'll obviously it's for their health, welfare, and benefit, but you wouldn't want them to get that outright and throw them off of um, their government
Yeah.
aid in that case. And there are other, scenarios, if they, have chronic illness, maybe not, or maybe they aren't good with money. Maybe they're going through a divorce,
Yes.
and therefore having it go to the trust is probably imperative and the prudent thing for them to do. So there are so many different examples that you really have to look at each scenario independently and
Mhm.
see for that client what works for them. Ideally, if you can name an individual and if it's a see-through trust where individuals are adults and you can see every single
Mhm.
beneficiary within that trust, then it makes sense for the beneficiary to be named
Mhm.
outright.
Okay, yeah, that makes sense. And what you're saying too is a trust is adding guardrails. I mean, that makes a lot of sense. And
Correct.
naming individuals is most of the time clearer, but we can flex that a little bit depending on the situation. And so do you have an example of this or anything else?
Well, let's see. We kind of talked about, the um, see-through trust, and I
Mhm.
had a client that named her trust as a beneficiary of her IRA, but the trust wasn't a see-through trust, meaning that it didn't have the beneficiaries quite named, that um, it wasn't qualified as a see-through trust, and
Okay.
because of that, the IRS treated that differently, and therefore the distribution comes out faster and at the higher tax rate. Trusts, when there's a trust tax return done, it
Mhm.
is at the higher tax rate, and
Mhm.
sometimes you can K-1, it's like a 1099 to the beneficiaries, but in this case, it didn't qualify, so they couldn't take it at their own individual
Mhm.
tax rate, and so that was not the most tax advantageous way, if that's the right word to,
Yes.
say, you know, and
Yeah.
therefore it was, yeah, it was not a good situation to have the trust as the beneficiary.
Yeah. So the big takeaway here is that you shouldn't just guess and you should talk, whether your name
Mhm.
whether you name a trust or individuals depends on the family situation, your goals, and your estate plan.
Yeah, there isn't a one size fits all in this scenario. And that's why you really need to look at all the variables involved and seek the professionals
Yeah.
and make a more educated and prudent decision. And this, find those that are estate planners, find ones that love to uh, delve into this area, those financial planners that are knowledgeable in this, and make it a part of your annual review. That is
Mhm.
really the key. And make this an added value. They will love you for it. You will save them so much and give them peace of mind. That's
Mhm.
a key factor here.
Yeah. And so when clients work with you, how do you guide them through this process? I mean, for our financial service professionals that are listening and watching, how what advice can you give to them to walk through this with their clients?
We actually, at our annual review, will ask them to bring in those beneficiary forms,
Okay.
or, contact your 401k or your 403b. Any of those external ones where we're not involved in that,
Mhm.
we want them to be proactive and seek out what the beneficiaries are on there. When we actually do the financial, or excuse me, the estate plan for them. We handle the funding. We talked about this in our most recent Women in Business conference. What happens when, after the delivery of that estate plan? We actually take it a step further and we set up a funding appointment because, as
Mm,
you know, most of us may or may not know, the trust is just a shell until
mhm,
you actually fund it. And the way that you fund a trust is by getting the assets into there. And the way that you get the assets into the trust are by naming the trust as the owner of those assets or naming the trust as a beneficiary, whether it's a primary beneficiary or a contingent beneficiary. And so we incorporate that into our process. We also, do this through Generational Vault, and we go through their documents. By then, we've had all of their outside documents loaded in there, and we can go through each one and say, "Okay, so here's your bank account. Where, who do you have this um, going to? Do you have a transfer on death on this bank
mhm,
account, on your money market, on your CD, on your employer plan?" We go through each and every single one of them and guide them through that process so that when they leave there, they have an action plan and they know.
mhm.
And then we follow up about 2 weeks, maybe a month later, and find out whether or not that has been completed. And of course, a year later from then, we are also doing that annual review. So there are also checks and balances so that
Mhm,
we are doing our job to make sure that we've done everything in our power to ensure that they've
mhm.
funded and properly put beneficiaries on their trust.
Yeah, absolutely. And like you said, it's not just paperwork that we're talking about. It's protecting families from legal headaches and probate, which no one wants to go to, and ensuring money goes where the heart intends.
And I'll say it's not just their trust, but on all of their assets. I wanted to kind of
Yes.
backtrack and correct myself, but yes, by yeah, going through all their statements. So yes, you're absolutely right. Um, when they're done with this, they're gonna have the best night's sleep and have peace of mind. And frankly, they don't want to see us for a year
Yeah.
after
Yes.
that.
Yes. And all right, Karen. So, time for kind of the key takeaways here. What's one action step that our listeners should take today?
Schedule those annual reviews. Go and look at you might have to go to your marketer and ask them about that beneficiary report. Um, Reach out to Connects Me and ask them about that beneficiary report that we have and start incorporating that into your annual reviews. When you do schedule that annual review, ask your clients to bring in all of their statements, review their bank accounts, their outside external accounts, their internal accounts, and determine what their current beneficiary situation is.
Yeah. Well, Karen, this is a fun-filled topic. I mean,
Ah,
not really, but you even made a comment about how we could be talking about this for over an hour.
oh my
And
gosh, we can go down the rabbit hole on this and incorporate into this how RMDs impact um, the designations of
mhm.
beneficiaries and inherited IRAs and how
Yes.
that can be. We can go on, and even from a trust standpoint, the property, how property gets
Yes.
designated within this environment. So yeah, maybe there's other podcasts that we can do.
Well, I mean, you just gave great advice. And before we kind of clock off, one, I just want to note that Karen and I did not plan this matching
Oh,
today, but we're both rocking the leopard print. So we're on the same attitude, the same, you know, wavelength today. Is like
we've got the cheetah vibe here.
Yes, and the energy to match it, right? And so, Karen, just a fun little question before we close out. What would you be doing right now if you weren't in the financial world?
I would be doing life coaching. I love or financial coaching. I mean, I kind of am incorporating a little bit of financial
Okay.
coaching into our business, but I love life coaching or for craft. If I was like completely retired, sitting by water and maybe doing calligraphy.
Oh, I like
I
that.
do. I love doing calligraphy. I'm not very crafty, but
Do you
I
have the
do.
calligraphy pen?
I do.
Okay.
I do. And markers and
Yes.
yeah, I used to dabble in that for a while, but
Mhm.
yeah, that's probably something chill like
Yeah.
that.
Well, I'm sure you have great handwriting then.
Oh, yeah. Hey, yeah,
Uh,
that's the parochial school upbringing.
Absolutely. Well, Karen, is there anything else you want to add before we close out?
You know what? It's been a pleasure, and I love our women in business, and so grateful to Chuck and Tammy Lucius and Gradient Financial Group. Tammy has been the founder of this Women in Business, and her vision has come to fruition. I'm so grateful that I've been on that journey with her through this. And um, I'll tell you, I love the networking that I've had. Shout out to my lady bosses, and I'm grateful for this opportunity. Thank you for inviting me. I appreciate it.
Absolutely. I'm so glad that we got to meet and to have you on here with me. It's been a pleasure for me too. So
Oh, you're awesome.
you
I'm
are
so
too.
glad. Thanks.
All right. Well, to our listeners, make reviewing beneficiaries a standard part of your process and your practice. It's one of the simplest ways to protect your client's legacy and your reputation as their trusted advisor. Thanks for tuning in to Gradient Women in Business. Don't forget to subscribe, share this episode with another advisor who could benefit, and join us next month for more insights for women empowering women in finance. Thank you.